All right, so we're diving into something that I bet a lot of you out there in California are thinking about, especially if you're renting and like that month-to-month flexibility, but maybe aren't so sure about things like how much notice you need to give or how much your landlord can bump up the rent, all those things. What are your actual rights when you're in that kind of agreement?
Yeah, that flexibility can feel like a bit of a double-edged sword sometimes. But the good news is California law actually gives you some pretty solid protections as a tenant. And today we're going to really unpack all of that so you can feel confident about what your rights are.
Perfect. Let's start with the basics. What exactly, in like the legal sense, makes a month-to-month agreement different from a regular lease?
So you're right. The name kind of says it all. It's a lease, but it doesn't have a fixed end date. So it just keeps renewing every month as long as both you and your landlord are happy with things. The big thing that sets it apart from a fixed-term lease is that either side can end it with proper notice. It's almost like, think of it like a subscription service. You can cancel anytime you want, but you have to follow their rules.
So less commitment than a traditional lease, which is awesome for flexibility. But yeah, maybe a little bit more anxiety-inducing at times. And speaking of anxiety-inducing, let's talk about that termination notice. How much notice do you actually need to give in California? And it's the same for like the tenant and the landlord?
It's a really good question, and honestly, it's where a lot of people get tripped up. So here's the deal. If you've been living in a place for less than a year, both you and your landlord have to give at least 30 days notice in writing to end things. But if you've been there for a year or more, that notice period jumps up to 60 days. And that's for both of you.
Wait, really? 60 days? That's like 2 whole months?
It does seem like a long time, but it's all about trying to find a balance, right? That extra time gives everyone, you and your landlord, enough time to, to figure things out. If you're finding a new tenant or if you're looking for a new place, it gives you breathing room.
And let me just emphasize here, folks, get everything in writing. We actually came across a story where a tenant relied on just a verbal agreement with their landlord, and it turned into a total legal mess. When it comes to these things, verbal agreements just don't hold up in court.
100%. Put it all on paper and keep copies for yourself. It's always better to be safe than sorry, especially when we're talking about something as important as your home.
Now, here's where things get really interesting. Just cause eviction. Our research said this is a pretty big deal for tenants who have been living in a place for over a year. What makes it so important?
This part of California law is a huge protection for tenants, especially those who have been living somewhere long-term. Basically, if you've been in a place for more than a year on a month-to-month agreement, your landlord can't just kick you out for any random reason. They need a good reason, a reason that's specifically laid out in the law, and that's what we call just cause.
So it's not a free-for-all for landlords anymore, huh?
Nope, not at all. They can't just say, see ya, whenever they want, even if it's month to month.
Okay, so what are some of those just cause reasons? Like what would fly in court?
Well, some common ones are if you haven't been paying rent, or you violated your lease agreement, or if you're causing a lot of trouble that's bothering other tenants. But there are also situations where it's more on the landlord side, like if they want to move in themselves, or they have a family member who needs to move in, or sometimes even if they have to do big renovations or they're planning on demolishing the building.
So it's not always the tenant's fault. There are legitimate reasons for a landlord to end things too. But what if? What if a landlord tries to get sneaky and evict someone without a real just cause? What can a tenant do in that situation?
That's a really important point. Evicting a tenant without just cause, especially if they've been living there for over a year, is flat out illegal in California. If a landlord tries to pull that, the tenant absolutely has the right to fight back and challenge that eviction in court.
Knowledge is power, right? Knowing your rights is the best way to protect yourself. And while we're talking about that, let's talk money, specifically rent increases. Can landlords just raise the rent however much they want when it's a month-to-month situation?
Well, even though landlords have a bit more leeway to change the rent with month-to-month leases compared to a fixed lease, there are still some important limits set by California law. The amount of notice they have to give you depends on how much they're increasing it by.
Okay, so give us the rundown. What are the notice periods for different rent hikes?
Sure. So for any increase that's 10% or less, they have to give you at least 30 days written notice. But if they're planning on a bigger jump, anything over 10%, then they have to give you a 60-day notice.
Makes sense. Bigger changes need more time to get ready. Now, what about rent control? Does that apply to month-to-month tenants? And how does it affect rent increases?
Great question. Rent control laws can definitely have a big impact here. These are local laws that some cities have put in place to give tenants even more protection against huge rent increases.
So it depends on the city, not just the state.
Exactly. If you're renting in a city with rent control, there might be stricter limits on how much your landlord can raise the rent each year, no matter what kind of lease you have. It's always a good idea to check what the rules are in your specific city, because what's legal in one place might be totally different somewhere else.
So local laws really matter. It's not just about the state laws. You got to know what your city says, too. Okay, let's move on to something that honestly can feel kind of scary. Retaliation. A lot of renters are afraid to speak up for their rights, especially when it comes to things like repairs or safety concerns, because they're worried about their landlord getting back at them. So can landlords retaliate against tenants who are just trying to exercise their rights?
That's a very valid concern, and I want to be clear. In California, the answer is a big, fat no. California law is super clear about this. Landlords cannot retaliate against tenants for exercising their legal rights.
So like, if I report a safety hazard or join a tenants group, my landlord can't just try to evict me out of spite.
Exactly. That would be illegal retaliation, and it doesn't even have to be an eviction attempt. It could be things like unjustified rent increases or other actions meant to punish the tenant.
Okay, that's good to know. But for how long does this protection last? Is it forever?
The law specifically says that any retaliatory action that happens within 180 days, so about 6 months, of a tenant taking a protected action is illegal.
So they basically can't punish you for 6 months after you've spoken up. That's a pretty decent amount of time to feel safe.
Yeah, it is. And it covers a pretty wide range of tenant actions, like requesting repairs, complaining about things that make the place unlivable, even filing a lawsuit against the landlord, or being part of a tenants union.
Wow, okay. So we've covered a lot here. Notice periods for ending a lease, the just cause rule for evictions, limits on rent increases, and those important protections against retaliation. So, bottom line, what should you do if you get that notice from your landlord? What's the first step?
First things first, don't freak out. I know it's easy to feel overwhelmed when you get that piece of paper, but take a breath and remember what we talked about today. Remember your rights. Sometimes just knowing your rights can help calm things down or even keep things from getting worse in the first place.
Right. Don't let fear freeze you up. Get informed instead.
Exactly. So after you take a breath, go over that notice carefully. Make sure it's in writing. Check all the dates. And if you've been there for over a year, make sure it has a legitimate just cause reason for the eviction. If anything seems off, even a little bit, don't hesitate to get legal help. There are organizations out there that specialize in tenant rights, and they can help you figure out what to do and make sure your rights are protected.
That's great advice. Sometimes having an expert on your side can make all the difference, especially when you're dealing with legal stuff.
Absolutely. It's always better to be prepared. What I find really interesting about California law is that it really tries to find a good balance between the rights of landlords and tenants. It understands that month-to-month agreements need to be flexible, but it also puts in safeguards to make sure tenants aren't taken advantage of. It's like this careful dance between freedom and security, and knowing how both sides are protected is key.
I like that. It's not about landlords versus tenants. It's about making sure everyone is playing fair and the system is working for everyone. This has been super helpful, honestly. We've really dug deep into all the details of month-to-month tenant rights in California.
It has been quite a deep dive. There's a lot to know, and hopefully our listeners are feeling more empowered and informed now.
I hope so too. But before we wrap up this part of our deep dive, I want to leave you with something to think about, something we came across while researching. Here's the question. That automatic rollover feature of month-to-month agreements, the one that makes things so convenient and flexible, could that also make tenants a little too comfortable, maybe making them less likely to really pay attention to their rights or deal with problems with their landlord? Just something to consider.
That's a really interesting point. Sometimes when things are easy and just keep rolling along, we can forget about our rights and what we need to do to protect ourselves.
It's like being on autopilot, moving forward but not really paying attention. So as you navigate being a renter, remember, stay informed, know your rights, and don't be afraid to get legal advice if you hit any bumps in the road. You're not alone in this, and there are resources out there to help you through the sometimes confusing world of renting in California. We'll be back in a bit to continue our deep dive and uncover even more essential insights into your rights as a tenant. Stay tuned.
It's funny you mentioned that autopilot thing because one thing that can really catch renters off guard is how you can go from a fixed-term lease to a month-to-month agreement without even realizing it.
Oh, yeah, I've heard about that. It seems obvious once you know about it, but it can definitely sneak up on you.
Yeah.
So how does that transition actually happen?
It's actually pretty simple. Like, in California, if you have a fixed-term lease, say for a year, and then that lease ends, but you just keep living there and paying rent, your agreement automatically becomes month to month. It's kind of like, that gym membership you were supposed to cancel but totally forgot about. You're still stuck with it until you officially say you're done.
So you could go from that sense of security, that predictability of a fixed-term lease, to a month-to-month situation without even, signing a new lease or talking to your landlord about it.
Exactly. And that's where things can get a little complicated because once you're on that month-to-month agreement, even if it came from a fixed-term lease before, all those rules we talked about, like the shorter notice periods and the just cause eviction rules, those all apply.
Okay, so let's say, just as an example, you've been living somewhere for 2 years on a fixed-term lease. The lease ends, you get busy, you don't sign a new one, but you keep paying rent. Then, all of a sudden, your landlord decides they want their cousin to move in. Can they just give you a 60-day notice and kick you out?
Yeah, unfortunately, in that situation, they could. Even though you've been living there for 2 years, technically you've switched over to a month-to-month agreement. And once you're past that first year on a fixed-term lease, all the landlord has to do is give you 60 days notice with a valid, just cause reason to end things. And having a relative move in is usually considered just cause.
Wow. That really shows how important it is to pay attention to those lease end dates. If you want to keep that long-term security and those just cause eviction protections, you got to be proactive.
Totally agree. Don't assume things will just keep going the same way they were under your old lease. If you really value that stability, knowing what to expect, you need to make sure you either renew your fixed-term lease or talk to your landlord about signing a new one before the old one runs out.
All right, let's shift gears a bit and talk money, specifically security deposits. This is one area where there's a lot of confusion and sometimes even arguments between landlords and tenants, so knowing the rules is really important.
For sure. California has some very specific laws about security deposits, and they're designed to protect both sides, both landlords and tenants.
Okay, so first things first, what's the most a landlord can ask for as a security deposit in California? Is there a limit?
Yeah, there are limits, and it depends on whether the place is furnished or not. For unfurnished places, landlords can't ask for more than 2 months' rent as a deposit. But if it's furnished, then they can ask for up to 3 months' rent.
So if you're moving into a fancy, fully furnished penthouse, they might be able to ask for a bit more upfront, but there's still a cap. Now, once you've paid that deposit, what can the landlord actually use it for? Can they just take money out of it whenever they feel like it?
Absolutely not. California law is very clear about what that money can be used for. They can use it to cover unpaid rent, to fix any damage to the unit that's beyond normal wear and tear, damage that was caused by the tenant or their guests, and to clean the place if it was left super dirty.
So if I accidentally spill red wine on the carpet or my kid decides to draw all over the walls, they could probably take it out of my deposit. But if the paint is just fading because it's old, that's not on me, right?
Right. Normal wear and tear is the landlord's responsibility. It's part of owning the property. The security deposit isn't meant to be a way for landlords to pay for regular maintenance or upgrades. It's specifically for those things we talked about.
Okay, now let's talk about the part everyone loves. Getting that deposit back when you move out. I've heard some pretty crazy stories about landlords taking forever to return deposits or making up reasons to keep the money. So what's the rule in California about returning security deposits? How does that work?
California law is actually pretty good for tenants here. It sets a clear deadline. Landlords have to return the security deposit, minus any legitimate deductions, within 21 days after the tenant moves out. If they don't return it within that 21-day window, or if they don't give you a list of reasons why they're keeping part of it, you have the right to demand the whole amount back, and you might even be able to get extra money on top of that.
So there are real consequences if landlords try to mess around with security deposits. The law is there to make sure they're handling that money responsibly.
Right. The security deposit laws are all about finding a balance, protecting both sides, but they definitely hold landlords accountable.
So you're an expert in tenant rights. You've seen a lot. What's one of the biggest misconceptions you come across when it comes to month-to-month agreements in California? What do people get wrong a lot?
I think one of the most common things I hear is that tenants who are on month-to-month agreements think they don't have any rights because their situation is so flexible and could end at any time. They feel like they're at the mercy of their landlord, which can make them feel powerless.
Like they're walking on eggshells, always worried about being kicked out.
Exactly. But as we've been talking about, that's just not true. California law gives month-to-month tenants a lot of protections, especially if they've been living in the same place for more than a year. They have rights, and knowing those rights is the first step to feeling more confident and secure in their home.
It's about changing that mindset, going from feeling like you're at the mercy of your landlord to knowing that you have legal protections and a voice.
Absolutely. And it's important to remember that even though we're talking about laws and rules, this is ultimately about people's homes and their lives. It's about creating a fair system where both landlords and tenants can live and interact with respect and understanding.
Such a good point. It's not about creating conflict. It's about making sure everyone is treated fairly and respectfully. Now, we've talked about the legal side of month-to-month agreements, but we can't forget about one of the most basic things about renting: habitability. Even if you're the perfect tenant, paying rent on time and following all the rules, you still deserve to live in a place that's safe, clean, and in good working order.
Definitely. A landlord's responsibility to maintain a habitable dwelling is a fundamental part of renting, no matter what kind of lease you have.
So what does habitability really mean legally? What standards does a rental unit have to meet to be considered habitable?
Basically, it means that the place has to meet basic health and safety standards. The building needs to be structurally sound, it can't have any big problems that could put people in danger, and all the essential things like plumbing, heating, and electricity have to be working properly. It also means no infestations and keeping the place reasonably clean.
So things like a leaky roof, a toilet that won't stop running, or roaches everywhere, those would all be considered habitability problems.
Yep, all of those are violations of a landlord's duty to maintain a habitable place, and tenants have the right to take action if those problems aren't fixed in a timely manner.
What can a tenant actually do if their landlord isn't taking care of those habitability responsibilities? Like, say they've reported a problem multiple times, but nothing's been done. What are their options?
The first thing always is to document everything. Take pictures, videos, keep a record of every time you talk to your landlord, whether it's phone calls, emails, text messages, dates, times, everything. This creates a trail of evidence that can be really helpful if you need to take things further.
So don't just have casual chats or rely on phone calls. Get it in writing and keep those records organized.
Exactly. Documentation is key here. If you've reported a problem and nothing's happened after a reasonable amount of time, then think about sending a formal written notice to your landlord. Explain the problem, how it's affecting your living situation, and give them a reasonable deadline to fix it.
So it's about escalating things and letting the landlord know you're serious about getting the problem resolved.
That's right. If even a formal written notice doesn't work, you might want to reach out to your local housing authority or code enforcement agency. They can investigate the situation and maybe even give the landlord a citation for violations.
So there are resources beyond just talking to the landlord directly. You can get government agencies involved who have the power to hold landlords accountable.
Exactly. And remember, as we mentioned earlier, if the habitability issues are really bad and your landlord is just ignoring you, you might have the right to do something more drastic, like withhold rent or even break your lease. But it's super important to talk to a lawyer before doing anything like that.
Withholding rent seems like a pretty strong move, but are there risks involved?
There are definitely risks, and it's not something to take lightly. It's really important to talk to a legal professional before you withhold rent, because there are very specific rules about how to do it legally. You don't want to end up facing eviction because you didn't handle things the right way.
Makes sense. It's like doing surgery. You wouldn't try to do it yourself without the right knowledge and guidance. Now, in extreme cases where the habitability problems are really bad and the landlord is completely neglecting their responsibilities, can a tenant break their lease without being penalized?
In some situations, yes. If the conditions are so terrible that they're a serious danger to the health and safety of the tenants, and the landlord has done nothing to fix them even after being told repeatedly, then a tenant might be able to argue that they've been constructively evicted. It's like saying that the landlord has made the place unlivable, which means the tenant is free to leave without breaking the lease.
So it's not just about fixing a leaky faucet or something minor. Serious habitability problems can actually give tenants the right to walk away from the lease completely, but only in very specific cases.
Exactly. And again, I can't stress enough how important it is to get legal advice in these situations. A good lawyer can look at your specific situation, help you understand the right way to do things, and make sure your rights are protected every step of the way.
This has been so informative. I think we've busted a lot of myths about month-to-month agreements in California. It's clear that tenants have more power than they think, and the law is there to help them.
Absolutely. And it all starts with knowledge. The more you know about your rights and responsibilities as a tenant, the better you'll be able to handle the rental process with confidence and stand up for yourself if any problems come up.
Now, before we go to the final part of our deep dive where we'll share some practical tips and resources for California renters, I want to leave you with something to think about. Imagine a situation where a landlord keeps ignoring habitability problems. We know tenants have the right to withhold rent, which can give them some leverage, but could that also be a financial risk for them, especially if things end up dragging on in court? Just something to ponder.
That's a really good question, and it shows how tricky these situations can be. It reminds us that even though tenants have rights, using those rights sometimes requires careful planning, a bit of strategy, and maybe even professional help to avoid potential downsides.
Welcome back to the deep dive. We've been on quite the journey exploring all the ins and outs of month-to-month tenant rights here in California. We've covered notice periods, just cause, eviction, rent increases, retaliation, security deposits, habitability. It's been a lot.
It really has been, but we're not quite done yet. Now that we've laid the foundation and, made those legal terms a bit easier to understand, it's time to switch gears and focus on some practical stuff, some strategies and resources that can help you as a tenant.
Absolutely.
Yeah.
Because knowing the rules is great, but you also need to know what to do with that knowledge, right? It's like having a toolbox without any tools. Not very useful.
I love that. So let's start with one of the most important things you can do. Document everything.
Seriously, everyone, I can't emphasize this enough. Put it in writing, take pictures, keep records. It's your best protection if any disputes come up.
Think of it like building a fortress of evidence. From the moment you move in, keep track of everything. Your lease agreement, any emails or letters you exchange with your landlord, rent receipts, any requests for repairs, even text messages. You never know what might become important later on.
It's like those little details in a mystery novel that seem unimportant, but then they end up solving the whole case.
Exactly. And speaking of communication, whenever you can, talk to your landlord in writing. That way, you have a clear record of what was said, and it helps avoid misunderstandings and those he said, she said situations.
So even though it might be tempting to just have a quick chat or make a phone call, take that extra time to write an email or even a formal letter.
It's worth it, trust me. And even if you do have a conversation on the phone, always send a follow-up email or something just to confirm what you talked about and what you both agreed to.
Now, let's talk about maintenance. We touched on habitability, but what are some proactive steps tenants can take to make sure any problems with their unit are handled quickly and correctly?
The key is to be proactive and communicate well, but also be strategic about how you go about it. Always report any maintenance issues in writing, be specific about what the problem is, and suggest a reasonable time frame for getting it fixed.
Right. Don't just say the sink is broken. Explain what's actually happening, how it's affecting you, and maybe even take a picture or video to show them what you mean.
Exactly. Give your landlord a clear picture so there's no confusion. And if it's something urgent, like a gas leak or a major electrical problem, make sure you stress that in your communication. Let them know it's a safety issue and it needs to be dealt with right away.
So it's about being assertive without being, aggressive. And knowing when to take things further if your landlord isn't responding. So what happens if they're just dragging their feet? Even after you've tried to communicate the problem, what's the next step?
If you've already sent that written notice, gave them a reasonable time frame, and still nothing's happening, then send a follow-up notice. Remind them about the problem, how urgent it is, and that they're legally obligated to maintain a safe and livable place. If that still doesn't work, then you might want to think about calling your local housing authority or a code enforcement agency.
So you're saying there are other options besides just going back and forth with your landlord. You can involve government agencies that have the power to make landlords fix things.
Exactly. Those agencies can look into the problem, and if they find violations, they can issue citations and really put pressure on your landlord to get those repairs done. And like we talked about before, if the habitability problems are really serious and your landlord just won't do anything, even after you've tried everything else, then you might have the right to take more extreme measures like withholding rent or breaking your lease. But again, talk to a lawyer before you do anything like that.
It's like having someone guide you through a really complicated maze. You need someone who knows the way and can help you get through it safely.
I like that analogy. So we've talked about what to do when things go wrong, but let's talk about moving out. Even when everything goes smoothly, there are still things to keep in mind. What are some important things for tenants to remember when it's time to leave their rental?
Well, first things first, give your landlord proper written notice that you're moving out.
You got it. We've said it before, and we'll say it again. Written notice is your best friend. It protects you and prevents problems later on.
Absolutely. Make sure you give the right amount of notice. Remember, it's 30 days if you've been there less than a year, 60 days if you've been there a year or more, and make sure you give the notice in a way that you can prove they received it, like certified mail or email with a read receipt.
Right. Now, once you've given notice, it's time to start thinking about that security deposit. What can tenants do to make sure they get their full deposit back?
Yes, the security deposit. Any tips for maximizing those chances?
Definitely. First, take a close look at your lease agreement. Pay attention to any specific rules about cleaning or repairs that are mentioned in the lease. Some landlords are really picky, and you want to make sure you're meeting their requirements so they don't take any money out of your deposit.
And then it's time to put on your cleaning gloves.
Exactly. Give the place a really good cleaning. If you're not a fan of scrubbing and polishing, you could hire a professional cleaning service. It might be a good investment, especially if it helps you get that full deposit back.
And what about repairs? What's the best way to handle those before you move out?
If there are any small repairs that are clearly your responsibility, like patching a hole in the wall or fixing a loose doorknob, it's usually best to just take care of those yourself before you move out. It shows you're trying to leave things in good shape, and it prevents your landlord from deducting money for those little things.
It's like tying up those loose ends before you move on to a new chapter.
I like that. But for bigger repairs, or if you're not sure who's supposed to fix something, always talk to your landlord first. They might have specific people they want you to use or specific ways they want things done.
And one last thing that people often forget. Do a final walkthrough with your landlord before you turn in your keys.
That's super important. That walkthrough is your chance to point out any damage that was already there when you moved in and to document it. It's also a good time to confirm that you and your landlord agree on the condition of the unit. And you can double check their forwarding address to make sure you get your security deposit sent to the right place.
Okay, we've covered a ton of information today, from understanding the laws to practical tips for being a renter. I feel like we've given our listeners everything they need to confidently handle renting in California.
I agree. If there's one thing I hope people take away from this, it's that knowledge is power. The more you understand your rights and what you're responsible for as a tenant, the better prepared you'll be to stand up for yourself and have a good, fair rental experience.
Well said. And remember, you're not alone in this. There are resources out there, organizations that can help, and a whole community of tenants who have been through the same things. Stay informed, stay empowered, and as always, happy renting. Thanks for joining us on the deep dive.
Call now 714-442-9741. Thank you.